Hi, everyone. This is Sasha with the LTRC. Thank you for joining us for the roadmap to help your clients comply with CPRA in 60 days. With our sponsor, Exterro, as part of the LTRC Industry Insights Series held every Wednesday. Our speakers today are Rebecca Perry and Robert Fowler. Rebecca Perry is the Director of Strategic Partnerships at Exterro. For over 27 years, Rebecca has worked with legal, IT, compliance, and privacy professionals alongside their outside counsel to help their companies manage data and information in compliance with legal and regulatory obligations while mitigating risk and reducing costs. She's been a certified information privacy professional for the last 10 years and has been in the trenches with clients addressing GDPR, CCPA, NYDFS, and other similar requirements. Rebecca helps manage relationships with leading law firms and legal service providers and speaks frequently to industry groups like today's GC, the Association of Corporate Counsel, ALM, Compliance Week, IAPP, and ISACA. Robert Fowler is the Director of Strategic Partnerships at Exterro. Robert has over 16 years of experience helping legal, compliance, privacy, and IT executives in the area of information governance, data mapping, data minimization, and third-party diligence. He has helped hundreds of leading companies develop and maintain comprehensive data inventories to comply with expanding data privacy regulations and implement defensible data minimization and deletion strategies to dramatically reduce the amount of email, electronic information, and paper records. His extensive experience and knowledge of information governance and data privacy requirements enables him to help clients establish effective processes for ongoing compliance. Robert is a certified information privacy professional and has an MBA in business administration from Webster University.
Awesome. Well, thank you, Sasha, and thank you, Robert, for pulling up the slides. I'll just kick us off, if that's okay, real quickly with an introduction to Exterro, maybe a new name for some of you. Exterro is really the leading provider in e-discovery, data privacy, digital forensics, and cybersecurity. And these, as we've all probably seen, are four areas that are really converging, and it's becoming more evident in today's legal world. Exterro's legal GRC platform really harmonizes all of these areas and provides a holistic approach to cover the specific requirements that organizations face in mitigating risks and demonstrating compliance. So with that background, we can go on to the next slide. One key thing I think to note about Exterro is that we have been recognized for the last 15 years as an Acc Alliance Partner. We're really trusted in the legal community in this space, and I think this is a real testament to that. And in fact, 2 years ago, the Association of Corporate Counsel named Exterro their exclusive alliance partner for cybersecurity, compliance, privacy, and e-discovery, an important thing to note there. All right, and we'll go ahead and dive into our topic today. I know we have limited time. Really want to just set the stage in terms of the environment today when it comes to data privacy. And what we're really seeing in 2021 is that CLOs and general counsels, they have their eyes on data. There's data breaches, there's ransomware attacks, there's regulatory changes in terms of data privacy. All of those things top the list of CLOs, and for really good reason. What we're seeing now is a new frontier in rapidly expanding data privacy and cybersecurity regulations, and it brings with it tremendous legal liability and financial liability to organizations. Now, the GDPR really spurred global data privacy trend, and it's really made its way to the US. And I think it's a real testament that legal teams now need to know with great certainty the specific types of personal data that their organizations have and maintain, who they're sharing that with, inside the organization, outside the organization, their infrastructure that houses that information, and how long they're keeping that information. But unfortunately, a lot of corporations and companies aren't adequately prepared. We can go ahead and move to the next slide. So that's sort of the landscape that we're dealing with on a global level, but dialing it in specifically to what's happening in the US. We're seeing, just like with data breach laws, California led the way, and now all 50 states have data breach regulations, and California is doing it again on the privacy front. So we started with the California Consumer Privacy Act. It's in effect. Then Virginia passed a law, and California didn't waste any time amending the CCPA and strengthening that with the California Privacy Rights Act, which was a ballot initiative. And really kind of focusing in on the California Privacy Rights Act, it brings the requirements within California more in line with what we've seen in the GDPR. There's now data minimization obligations, purpose limitation, which means that companies can't keep personal data longer than necessary, whether that's a business, a legal, or a regulatory obligation. It also brings in other requirements for understanding and managing very sensitive types of information and limiting how long they keep that as well. And brings in more requirements similar to what we see in GDPR in doing data protection assessments. So it comes down to really knowing their data and understanding the risks around having that information. And most recently, Colorado just added a very similar law, falls a lot in line with the Virginia requirements, which also have data minimization and purpose limitation. And that's key. So if we move to the next slide, kind of dialing in on this point of data retention and deletion. It's really no longer optional for companies to begin to address this. It's essential for companies when they are telling consumers or employees, hey, here's the type of personal information we collect on you, and here's how long we're going to keep that information, having that transparency and that notice. Only collecting what you need to do the purpose of why you're collecting that information. That's data minimization. And of course, purpose and storage limitation. So it's no longer optional. Companies really have to bridge this gap between their current efforts and incorporating data retention as a key component of that.
Yeah, and so, now we'd like to really kind of start talking about, okay, we know the landscape, the backdrop that organizations are facing, and really start to dial into, what are things that they need to be doing in order to comply with privacy regulations. And we thought we would start with some of the challenges organizations face, right? Because if a lot of these things were easy, everyone would do it. And so some of these, as we talk through them today, I think will resonate with many of you on the call, because you may be dealing with clients who are struggling with this. And one thing to note as well, a little bit about Rebecca and I, our background is we've been working for over a decade now, really closely with different strategic partners, law firms especially, who have clients that just see a real value in leveraging some technology to help with some of these processes. So as we talk today, what we hope you see is that there's some value in leveraging technology to make some of this a little bit less challenging. So a couple of the things that we hear very often, and maybe you do as well, when it comes to creating the inventory, the data inventory, the data map, is, okay, it takes too long, right? Pretty much every law firm we talk to always recommends a data inventory for their clients, right? It just makes sense. And then they send them away, and they don't hear from them for a long time, right? Or ever again. And a lot of times what happens is organizations try to do this themselves, and they try to leverage spreadsheets and come up with questions. It takes too long, and it's a project that never ends. So that means you have an incomplete map. And it also means that you're probably going to have to start back over because it's taken 6 months, a year, 18 months, right? So we see a lot of these that are taking too long. They're incomplete. Once they're done, they're actually not done because you need to keep this thing up to date. So they're out. A big factor here, as we talk, the importance is there's no better time to turn those business mind. Rebecca and I have been at this for many, many years. When we first started in this space, really one of the main reasons organizations cared about records retention was because they've gone through a really terrible litigation experience or an e-discovery experience. And once the dust settled, They said, how can we make sure we never have to go through this again? And folks like you know, outside counsel perhaps would say, well, have less stuff, right? Make your haystack smaller. So the next time you go through this, you don't need to be searching through as much, because that's where the cost is. Flash forward or fast forward to where we are today, and litigation and e-discovery is still a risk organizations face, of course. But we also see things like data breach. Rebecca mentioned ransomware. That's really gaining steam, right? Even more than we've seen. We've just really seen that pick up lately. Different enforcement actions with privacy regulations, not to mention class action litigation that can come out of things like the CPRA. So there's a big difference now between, you know, keeping everything forever because, oh, it would be nice to have this in case my boss or someone asks for it, to really changing the thinking around this and only keeping what we need to have specifically to run our business. And that's a paradigm shift, and something that I think everybody is slowly getting a little bit more used to. Another challenge or, you know, misconception that we hear a lot from legal teams is we need to update our retention schedule. If I had a dime for every time I've heard that in my career, I'd be on a beach somewhere. Right. And the question that we're always asking is, okay, great, we can help you update your retention schedule, but let's wave a magic wand and tell me what happens to your business once you have an updated schedule, right? Like what is that going to do for you? And what we're driving at here is it really requires operationalizing, right? It really requires that you're tying the retention periods to your record types, to your personal data, but that you actually have the retention schedule in a format that the business can understand, and one that is going to really work and allow you to start defensively deleting data. And so if your retention schedule looks anything like the one we're seeing here today, we love our little doom graphic, right? You're probably going to be facing an uphill battle to get this implemented because it's just too hard to utilize and to leverage. Another thing that I think is interesting to point out, especially for this audience today, is what we have seen, and maybe you all will relate to this, but what we've seen over the last 6 to 12 months is a real uptick in a lot of our law firm partners coming to us and saying, hey, I have a client that's wanting to update their retention schedule. Hey, a client's interested in tackling retention. So we're starting to hear more and more of that, especially with these privacy regulations coming down the pipe. And so I think you're going to, if you're not hearing and getting questions now, I would anticipate that those are probably going to, you know, begin to be coming soon. So I'd like to turn it over now to Rebecca. And, you know, Rebecca, can you just talk a little bit about, you know, some of the keys to, you know, really going about this, especially, you know, keeping this up to date and from an ongoing compliance perspective?
Absolutely, Robert. Thank you. Yeah, so one of the things, you know, we've covered a lot very quickly here, but one of the keys, I think, you know, to bridge the gap wherever companies are today in their privacy compliance, but to get them ready for new regulations on the horizon, to get them ready for CPRA in 2023, it comes down to having an effective data inventory. And that data inventory is going to help inform a lot of these other areas of risk that we've kind of touched on. Key to that is retention. One of the things that you're going to see in our process is that we're able to tie in retention considerations based on best practices. The data inventory is going to inform how companies respond when they get consumer rights requests under CCPA, CPRA, GDPR, and any of the other forthcoming regulations as well. It's going to help surface vendors that may have access or are touching the company's data that pose a level of risk. It's also going to be very useful in the event that there is some sort of incident, a breach, a ransomware attack, and companies quickly need to determine what was the potential scope, what was potentially impacted. It's going to help drive and inform those privacy impact assessments that are required under GDPR and now under CPRA and some of the other regulations. So it really is the heart of your program. And if companies haven't done that, you know, well, maybe they're managing it in spreadsheets today. They've done maybe only looked at applications. They're going to struggle. So go ahead and move to the next slide, Robert, and I'll kind of illustrate and walk through this, all of these different key elements that need to be considered and incorporated for a data inventory to be effective, but also actionable and defensible, because as we talked, There's most likely programs are going to come under scrutiny, and going through this type of a process is going to enable companies to be in the best position possible. And it's also going to help inform outside counsel and, providing really solid legal advice. You want to be armed with this information to help your clients put the right policies in place and put the right disclosures and other considerations in place. And so, I've got two illustrations here. One's for consumer data and employment information. A lot of companies that have been hyper-focused on just consumer data because that's how it was defined within the CCPA. But as we've mentioned, employment information is very much at play under the CCPA in terms of rights. In 2023, employees could have rights to request their information. So it's important for companies to really take a broad look at this and not just focus on, consumer information. So understanding the applicability, identifying those very specific data subjects that are associated with all of your business processes are key. Tying in the specific elements of personal data that you collect, manage, or store on those data subjects, how you're getting that information. One of the key things that is often overlooked is how are the departments interacting with that information? How are they managing it, touching it, sharing it? Applications and locations. One of the gaps that we typically see with organizations is when they're doing their data inventory is they only focus on applications and they've missed all of these other areas that they need to be looking at to really kind of complete the picture. Locations, third parties, and then of course incorporating retention. This is going to help surface risks, it's going to help set priorities, and it's going to help inform legal guidance. It really is the foundation of a solid program. And so, Robert, I'll hand it back over to you to kind of talk through that 60-day process, what that looks like, and how we can help companies really get over the finish line and build that data map that we just walked through.
Yeah, absolutely. And one thing too, I wanted to mention, we will have a few minutes at the end for questions and answers. So by all means, if there's any questions that you have in the audience, you can enter them into the Q&A and we hopefully will have a couple of minutes here that we can tackle some of those. So yeah, we'd like to really walk you through, what does this look like for an organization? A lot of the partners that we work with, especially within law firms and other organizations, are really motivated and trying to get their clients to take that first step, which is to create an inventory so that they can understand their data. As Rebecca said, it really helps inform a lot of other decisions that organizations need to make. And it really, from what we have seen in our experience, is a treasure trove of information for outside counsel, right? Because it's really going to help you understand your client and how they manage data and what they have, what they're doing right, and what they could improve on. And so wanted to share with you what it looks like to engage in this 60-day inventory that does focus around retention as well. So a couple of things that I think are really critical to understand about Exterro and our process. We're really proud to say that we really pioneered the data inventory process by leveraging technology. We've been doing this for decades. Again, I mentioned we really started doing these sorts of projects, helping companies develop retention programs to combat litigation and e-discovery expenses by having less data. But we really have a refined process. So a couple of things that are unique, I think, is we're leveraging technology, of course, to help create these inventories. We engage with business people, but this process moves really quickly. So we're talking about 1 or 2 business people from each area of the company and a process that takes them about 60 minutes. Departments with more record types and processing activities, maybe 90 minutes. But this really, we look at this as a way to really eliminate a lot of the guesswork. It also eliminates a lot of the friction in getting this sort of information. And it gets the client out of the game of trying to create questions and answer sets and fill out spreadsheets, which really does not work. So the way that we go about this is we start with our templates of record types, processing activities, sensitive categories, third parties, applications, you name it. Because we've literally done thousands of these engagements, we come to the engagement with the client really ready to start the inventory on day one, because we know the kinds of record types that exist in an HR department or the processing activities. We know the typical applications that we tend to see. And so we're really able to start these and move really rapidly. From there, once we've gone out and started to ask those questions and create those data inventories, that's when we then can tie our retention, our best practice retention to those. And so again, for decades, we've been leveraging our best practice retention requirements, which take into consideration, all the different legal requirements to maintain records, not only for the United States, but globally as well. And we leverage industry best practices, and we have a scheduling logic to back that up. So one of the deliverables, if you will, out of an engagement like this, not only will there be a data inventory that understands their personal data and all sorts of different categories of sensitive information, but a best practice retention schedule that comes out of it, right? So they're really going to be able to start moving forward with the ability to start defensively deleting data and information, and they can rest assured that they went about it in a real defensible process, which, as you know, is really what everyone is striving for, is to do this in a way that creates comfort when they start actually hitting the delete button. So as you can see here, some of the deliverables, again, things like scheduling logic that come with this, executive highlights presentation, where we work directly with our law firm partners to share what we've learned. So, and we can then talk about next steps and where we can do some remediation and things of that nature. So it's a really great opportunity to have a real smart conversation with the client and talk about what we've learned. One question we get a lot is, how does this work? How does the project work, right? Is this just software that we are handed the keys to and expected to learn how to drive the car? Or does someone teach us how, where the gas pedal is and the steering wheel and you name it? And so our engagements come with a project team that is really there to help move the project in the direction of getting participants identified, getting the question sets final, and launching them, right? And so again, that's their specialty, and they've worked on hundreds and hundreds of these. So we move really briskly. When we say a 60-day project, we mean a 60-day project. And we're also really comfortable saying that the vast majority, if not all, of our engagements actually get finished. They complete their inventories, which oftentimes is not the case when they're going about it in a more traditional manual way. So yes, within 60 days, we are presenting the results and ready to really sit down and talk about what's best for the client on a move forward basis. And then finally, just wanted to share a couple of reports, couple of deliverables. If you're a visual person like myself, it's always nice to see, okay, what exactly are they talking about? So here you can see, this is an example of a processing activity. It's an HR onboarding processing activity, but this is the granularity of information that we're capturing as we go through this process, right? So understanding the purpose of processing, the different sensitive categories, the data subjects, all those things that Rebecca mentioned in that graphic a few slides ago. And then also we can really tie into, okay, from a retention perspective, right? Here are the different record types that were identified. If you notice in that center column where it says reported retention, that's what the business people said. That's how long they keep it. Permanent, right? Over and over and over again. That's what we see all the time. And then to the right of that are our best practice retention requirements. Very different, or at least 3 of the 4 of them. Than permanent, right? And so that's really what we're coming to the table with, is being able to present not only an inventory of their data, but tying the retention regulations to them so they can start to dispose of them as needed. So
I was just going to jump in. We actually had a question that was related to retention. So just thought I'd jump in, and I know we're near the end here, but it's, what are the various sources of law which impose retention requirements? And I think it's a great question, because while the GDPR, the CCPA, CPRA, Virginia, and all of the other regulations that, we're expecting to be coming on board, while they require limit on how long companies keep information, they don't define how long that is, right? And I think one of the key things that we've, kind of touched on is it's got to be related to the context. Why do you have that information in the first place? What is the business process that it supports? Do you have social security numbers because it's related to your HR onboarding? Or is it because of a warranty perhaps that you have that you're holding on one of your consumers? It really depends on the context. And so that's going to be the driver of what particular retention requirements, regulations could apply to that information. And there's various ones depending on the industry. In fin services, there's consideration like the OCC. For organizations, it could be a state payroll consideration. So there's lots of different retention considerations, but it's really driven not by the type of personal data, but by the types of records that it's tied to.
That's right. Yeah, that's right. Terrific. No, really great question, and I appreciate the answer there. That's exactly right. So Rebecca's right. We are at the end of our time. This moved quickly today. So one question we often receive a lot is, okay, well, how do we get started in conversations? Of course, you can reach out to Rebecca or I. We'd be very excited to share with you a little more about Exterro, answer any questions you have, talk about what it looks like to partner with us. So very happy to do that. I'd like to, before I hand it back over to Sasha, just thank everyone for joining today. Rebecca, thank you for your insights and sharing your perspective on our session today. And hopefully everyone found this to be very useful and very helpful. And I hope to hear from many of you soon. And with that, I will hand it over to Sasha.
That is all the time that we're going to have today. I would like to thank our sponsor, Exterro, and all of you for attending our webinar today as part of the LTRC Industry Insight Series. If you are curious about future webinars, you can check out the ABA LTRC page or follow our Twitter at LTRC for updates. I would also like to thank Rebecca and Robert for presenting today. You can keep up with Exterro at Exterro on Twitter or exterro.com. We will now conclude the webinar. Thanks, everyone.
Thank you.
Thank you.